Hello everyone, I'm Aratrika Bhaumik and welcome to LiveLaw. In a landmark judgment, the Supreme Court today passed an ad interim order allowing an unmarried woman to abort her pregnancy of 24 weeks arising out of a live-in relationship, subject to a medical board constituted by AIIMS Delhi concluding that the fetus can be aborted without risk to the life of the woman. The court underscored that allowing the woman to suffer an unwanted pregnancy will be contrary to the object and spirit of the Medical Termination of Pregnancy Act 1971. A bench comprising Justices D.Y. Chandrachud, Surya Kant and A.S. Bopanna was considering the appeal filed by the 25-year-old unmarried woman seeking termination of her pregnancy of 23 weeks and 5 days against a Delhi High Court order refusing her the said relief. The woman had apprised the court that although her pregnancy arose out of a consensual relationship, she could not give birth to the child as she was an unmarried woman and her partner had refused to marry her. She also mentioned that she is the eldest among 5 siblings and that her parents are agriculturalists and thus in the absence of a source of livelihood, she will be unable to raise and nurture the child. A division bench of the Delhi High Court comprising Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad on July 15th had opined that an unmarried woman whose pregnancy arises out of a consensual relationship is clearly not permitted to terminate her pregnancy older than 20 weeks under any of the clauses of the Medical Termination of Pregnancy Rules 2003. You can refer to our previous video where we have analyzed the Delhi High Court judgment in detail, the link to which has been provided in the description below. Referring to the impugned Delhi High Court order, the Supreme Court today observed that the High Court had taken an unduly restrictive view of the provisions of the Medical Termination of Pregnancy Rules while declining the woman's prayer. For context, Rule 3B permits only certain categories of women to seek termination of a pregnancy between 20 to 24 weeks, and one of the categories stipulated is change in marital status of woman followed by expressions widowhood or divorce. Referring to this particular provision, the Supreme Court today underscored that the expression change in marital status must be given a purposive interpretation and that the petitioner should not be denied the benefit merely on the ground that she is an unmarried woman. The Supreme Court today also noted that the 2021 Amendment Act had replaced the phrase by any married woman or her husband with the phrase any woman or her partner, which shows the legislative intent to cover unmarried women as well, in consonance with Article 14 of the Constitution of India, which guarantees the right to equality. Thus, the Supreme Court directed the AIIMS Delhi director to constitute a medical board, and the board has been asked to furnish a report determining as to whether the pregnancy can be terminated without the possibility of any harm being caused to the petitioner. The court also issued notice to the Union government and has sought the assistance of Additional Solicitor General Aishwarya Bhati on the legislative interpretation. Thank you. Keep watching LiveLaw for more such updates.